My name is Caroline Brooks. I'm a partner and trademark attorney at Abel Imray. Today I'm going to do this talk about tips for reviewing and building an effective trademark portfolio. This comes off the back of an article I wrote a little while ago, which has a checklist to help with the process of reviewing a portfolio and building a new one. And there'll be a link to that and to the checklist at the end of this talk. So we are going to cover today, it's pretty basic trademark stuff. Hopefully it will be a useful refresher for those of you who haven't thought about trademarks recently, and equally a useful introduction to anyone new to the subject. So I'm going to briefly talk about what you should be registering, where you should be registering, what goods and services you should be covering, kind of some tips on filing strategies, how to get that protection in a cost-effective way, and thinking about existing trademark portfolios where you have those. So, what should you register? Well, usually the first priority would be to register your word mark in block capitals. I've got an example here, the word union. The sort of understanding is that if you have a trademark registered in block capitals, that gives you protection for the same or similar word in any stylized form, so it's a really powerful thing to have. The one time when it can be difficult to get a word mark in block capitals is where your mark is a bit descriptive or not very distinctive in respect to the goods and services that you're interested in. In that case, it can be quite difficult to get a registration because trademarks are examined and assessed for their ability to function as a trademark. If you've been using some words which are a bit descriptive for many years and people have come to recognise them as a trademark, they may be registrable by virtue of the use you've made. Otherwise, you might need to file for a stylised logo form of the mark, which would be more distinctive. So that's the second thing to think about registering in a normal scenario, a logo form of the mark. Now, whilst you might ask yourself, why would you want that when the word mark's supposed to cover any stylised form? But actually, it can help you in a situation where someone uses a slightly more different word, but in a similar stylized way. So I have an example where one of my clients, they had union registered and somebody was using the mark onion. And actually, if you compare union and onion to most English speakers, they're not confusingly similar. Like they've got completely different connotations in the world, and you might have difficulty proving trademark infringement. But then if you look at how the infringer was using the mark, it was like this. So we were very grateful that in the relevant country we had this mark registered, because suddenly there is quite a high degree of similarity. There's no question really that the third party was trying to copy my client's mark. So actually it's quite a good idea to get the logo form registered. It helps you, it gives you a better degree of protection in respect to third parties. Other things you can think about registering are colours per se. So if you think about Milka chocolate, that has a very specific purple colour, which is registered in some jurisdictions. Strangely enough, Cadbury's also have a different shade of purple, which is also registered in some jurisdictions. So colour marks, they're difficult to get and they are quite narrow in scope, so they only apply to a specific shade. But in some scenarios, that's something people look to register. Similarly, the shape of a packaging or the shape of a product can be registered as a trademark. It's difficult to get them registered, and quite often you have to file evidence to show that people have come to recognise that as an indication of trade origin. But these are things that you can think about. They're pretty peripheral, they're less important than the word marks and the logos, but they are worth thinking about. Another thing that you can consider registering is your strap lines and slogans. Those again are quite hard to get registered. Every little helps, four-sprung duck technique, that kind of thing. They are difficult to get, but they can be very valuable if they're important marks to you. A general rule when you're trying to decide whether to register something or not is if you would be unhappy to see a competitor using an identical or similar mark, it's generally worth seeking registered protection. One thing to think about, which is sort of outside the scope of this talk, but definitely adjacent to it, is registered design protection. So registered design protection protects the shape or configuration of something. It's not really about indications of trade origin like trademarks are. It's just protecting the appearance of something. And this can be applied in the sort of trademark space to new logos, packaging, characters on packaging or in advertising, or the product design itself. The key word here is new. registered design protection is only available up to 6 months from the first disclosure. And in some jurisdictions, you need to get in quicker than that. So they need to be new things, you need to think about it early, but it can be very useful. Trademark registrations, you have to specify the goods and services that you're using the mark for. Registered designs are different. You do have to put in the indication of the product, but that doesn't define the scope of protection. So protection is not limited for design registrations to particular goods and services, so it can be a very powerful tool to have that registered. So where should you be registering your trademark? Ideally, anywhere you're trading. In practice, the key markets where you're trading and countries where you manufacture are the ones you want to think about. China is quite a specific case, sort of notorious for enforcing trademark rights. They've actually got a lot better, but there's a lot of third parties there who watch the registers in other countries and get in first and register a mark in China and then block the genuine proprietor from filing their own application. I had a situation where one of my clients was manufacturing in China. They hadn't registered their mark. A third party did register that mark, and then my client's products were blocked at customs and were not allowed to leave the country because they infringed a registered trademark in China. The client needed those to be released quickly, so they ended up paying a lot of money to buy the registration from the third party so that they could get their products out of China quickly. So if China is somewhere where you're manufacturing, or if it's of any interest to you at all, it's worth getting in quite early with a registration if you can. So typically trademark rights are territorial and you have to file trademark rights are territorial and typically you have to file country by country, but there are some systems to make it a bit easier. So there's the European Union trademark, which covers all 27 EU member states. We can help with that. We have an office in the Netherlands, so we are able to file directly at the EU IPO. It's a really good system. It's so much cheaper than filing in all 27 EU member states. It's well worth using. There's also an international trademark system called the Madrid Protocol. This basically allows you to file one central application and designate any number of countries that are part of the system. It means you end up with one registration, sort of a bundle of rights in lots of countries tied together to this one registration, which can be administered centrally. So you can renew it centrally. If you transfer it to another company, you can transfer it one thing rather than 25 things. There's about 110-ish countries that are now part of that system, which includes some of the really significant ones, the US, the EU, China, Canada. So it's really, really useful as well. Priority is something to think about. This is useful for new marks. This is a mechanism that means that after having filed your first application for any given trademark anywhere in the world, you then have a 6-month period in which to file overseas applications, and those can be backdated to the date of filing of the first application. So this means you can get in somewhere, file one application, see how things are going with your product or service, and then if things are going well, about 5 months later, you can file in other countries and you still get your rights backdated to the first filing day. So that's a useful thing to use when it's a new mark that hasn't been filed anywhere before. Helps you spread the costs a bit. So what goods and services should you cover? So in a trademark application, you need to provide a list of the goods and services for which the mark is to be used or is being used at the moment. For the purposes of trademarks, all goods and services are split into 45 classes. It's quite an old, creaky, arbitrary system. It's a bit, it's a bit of a minefield, but it works reasonably well. You need to think when filing an application, what are your current activities and what else are you likely to do in the next 5 or so years? If you're selling goods, do you offer any associated services? Do you install products? Do you maintain products? Do you offer training, consultancy, advisory services, anything like that? It's not a very good idea to go too broad, as that can lead to unnecessary conflict. You might overlap on paper with some other third party where actually in real life there's no conflict at all. So you don't want to go too wide. And in the UK in particular, you need to have what's called a bona fide intention to use the mark in the UK. So if you put down things which you're clearly you have no intention to use the mark for anytime soon, that could be bad faith, basically. So it's a kind of fine art getting enough but not too much. And it's worth thinking hard about this at the start so that you get sensible protection. But you can always file more things in the future and supplement that with new applications. So a filing strategy, it really depends on how many trademarks you're thinking about, how many territories are important to you, but it can be useful to categorize marks based on their importance to the business. So you could come up with a kind of category 1 of your most important marks, and that should definitely include the house marks, which is what your company is, the reputation is in the house marks. So those are the most important. And you should make sure those are protected in all the countries of interest and in respect of probably the widest possible range of goods and services to reflect what you're doing. You might then come up with other tiers, maybe secondary brands, where you only protect them for the core goods or services of interest, and or only in key jurisdictions. You can have several tiers with different arrangements for each. It depends how many marks you have and how much you're needing to think about this kind of stuff, but it's useful sometimes to have some guidelines written down so you know what your thinking is, and when you revisit in 3 or 4 years' time, say, remember why you've done what you've done and what you might do in the future. It's also quite a good idea to stagger filings if you want to spread costs. Generally, other than with the priority claim, your protection will only run from the date on which you file an application in any given country for any given mark, but it can make sense to just say, actually, we'll do one this month, one next month, one the following month, and just stagger the costs. Trademarks, generally, the bulk of the cost comes on filing, or a large part of the cost comes on filing, and then there's prosecution costs thereafter, which can be spread over several months or even years in some countries. So it's the filing costs which are the upfront ones which can feel like a big hit. Later costs will depend on the jurisdiction and how complicated things get. So if you have an existing trademark portfolio, it's a good idea to look at it every once in a while to check that it is fit for purpose. The kind of questions to be asking yourself are whether you have protection for all the relevant marks. So do you have protection for current versions of logos? Quite often logos evolve over the years and people don't realise they haven't updated their trademark protection. It's a good idea to have protected the exact version you're using now. You also need to check that you've got all the different product names. If you've had new products and you haven't thought about registering them, you want to make sure you've got those registered too. You should think about whether you have expanded your range of goods and services and whether those are all covered in the specifications. This is the more tricky bit actually to check, because when you look down a list, it's like, oh yeah, that mark's registered, we're fine. But actually it might be it's only registered for some of what you're now offering and not all of it. So it's worth taking the time to look at the specifications of the applications, of the registrations you've managed to obtain, and make sure that they still cover everything that's of interest to you. Obviously, also, it's worth looking through and checking that each of these marks is protected in all the current key territories of interest, and there's nowhere that you've moved into that you've not thought about. It is also possible to make savings when you're reviewing a trademark portfolio and just not renew things. Sometimes there might be old product names which are really no longer of interest, and you might feel able to just let those trademark registrations lapse. You might also have old versions of logos which are definitely past it. You don't need those anymore. And also you might have old areas of activity. I don't know, you used to sell beverages, now you only sell confectionery. You might drop the beverage classes, things like that. So it is possible that this isn't always about spending more money. You can occasionally make some cost savings if you know that things are really no longer of interest. So that is pretty much all I was planning to say for today. Does anybody have any questions? Okay, well, in that case, I shall move on. Just to recap. Oh, hello. I'm afraid I can't hear you at all.
Can you hear me?
Oh, I can now. Yes, hello.
Sorry, my connection is not very good, I think. Is it working now?
Yes, just about, yes.
Okay, so thank you first. And it was relating to the last slide. When you change the name of the product, and how long would you advise to keep the previous name registered to avoid a competitor to use this old name to compete with the product that has a new name then?
That's a very
Would
good
you
question.
think that typically it works 5 years?
I can't hear you very clearly, but I think you said how long would it be sensible to keep an old product name registered for after you've changed the name? I think you're right, there is some merit in keeping it for a while to kind of keep your competitors off the grass, as it were. Probably, so registrations generally last for 10 years. It's probably not a bad idea to keep one in force for at least 5 years after you've stopped using, because trademark registrations generally can be challenged on the grounds of non-use if you haven't used a mark in the last 5 years. So up to 5 years after you stop using the mark, you could in theory still enforce it against a third party if they do something that's close to what's covered. So if you've definitely abandoned a product name and you're not using it and at least 5 years have passed, you're going to struggle to enforce that trademark thereafter. So, I mean, you can leave it on the register as a deterrent if you want to, but there's diminishing returns after you've stopped using it for 5 years on. So it's a difficult one. It's quite, you have to have quite some nerve to allow trademark registrations to lapse. But there are some cases where it's just clear cut that they're no longer of interest. Does that answer your question?
Yeah, thank you very much.
Okay, great, thank you. Any other questions before I move on? Okay, well, just to recap then, things to think about really. You need to consider what and where you should register, identify which goods and services are important to you, create and implement a filing strategy. So have something that tells you what you're doing and why you're doing it and helps you make decisions going forward. And keep an eye on your existing portfolio every once in a while to make sure that it is fit for purpose and you aren't renewing things you don't need to. So there's a link to my article and a checklist that goes with it in case that's of interest here. And we'll send that out to you, I think, again after this. So thank you very much. If ever you do want to have a chat about your particular trademark situation, we're happy to offer a free 30-minute consultation. So please feel free to get in touch with me when details are here. I'm happy to set that up if that's of interest. So thank you very much for your time today, and yeah, have a nice day.